SwayamPrabha. Digital India. Educated India.
So, welcome to all of you again in this session on Introduction to Law on Electricity. We will be today discussing the salient features of the Electricity Act 2003. Now, as I was telling in the last class that all the reforms which had taken place, these reforms could not resulted into the desired result, desired outcome. The independent power producers, which were invited with a lot of fanfare after liberalization of the economy in the year 1991, they could not added to their capacity to in generating segment. The reform in the distribution sector was almost a sort of a non-starter, because there was lack of political will to bring in necessary professionalism needed to assure the other players in the market that distribution sector will be working on a very autonomous way in the interest of the consumers and other stakeholders. So, that caused a lot of distrust in the market, and because of this very fact, the electricity boards was on the verge of financial collapse. They were not collecting enough revenue from the end consumers, as I said, either because of the absence of necessary infrastructure or the efficient manpower, or because of inefficient tariff system. So, ACBs failed to extend the necessary support needed to strengthen the upper layer of the segment, which is generation and the transmission. So, in the year 2001, when the chief ministers they met on the agenda of reforming the power sector, they agreed that this sector needs a sort of overhauling. Piecemeal reform is not going to do any good, and in that it was agreed that any change, any reform, any proposal to strengthen this sector, to make this sector competitive, is possible only when the lower segment, the bottom line, the distribution sector is adequately addressed. If this sector is not seeing the change, if this sector is not internalizing the change, if they are not participating in the change, then the effort put in for inviting private players in the generation segment, bringing professionalism in the transmission segment is not going to give a very welcoming result. And therefore, it was decided that the distribution segment, the utilities, they must aim to reduce transmission and commercial losses and must make all the attempts for augmenting the revenue generation. And in order to bring in the discipline, in order to compel the utilities to commit to the change, it was also decided that any financial support to the electricity board needs to be tied up with the performance displayed by them. So, performance based tie-up was, performance based financial support was agreed upon. Along with this resolution, parallelly an effort was being made to introduce a comprehensive change in the legal framework, so that what was being dealt under 1910 Act, for instance the licensing aspect, the role of the government under the 1948 Act, or the power and function of the Regulatory Commission, all these needs to be reformed. All these needs to be brought under one umbrella, and furthering this objective, consultation started taking place with the stakeholders of enacting a new law, and it was suggested that the new law must repeal the earlier existing legal framework governing the sector, and those were pre-independence law, that is 1910 Act, and two post-independent laws, that is 1948 Act, that is Electricity Supply Act, and then this Electricity Regulatory Commission Act. All these three laws were repealed, and in the year 2003, the country welcomed a new legal regime which promised 360-degree change in the legal landscape pertaining to this sector. Now, at this stage, let me briefly tell you that what are the salient features of the law, because I will be discussing some of these in detail in different modules of this course. Drawing lessons from the drive of privatization, 2003 Act introduced delicensing in generation segment, particularly the one which is based on thermal power. One for electricity segment, one for hydro based power plant, it was suggested that techno-economic clearance is to be obtained, and because of the very obvious reason that hydro based power plant makes an impact on environment, and that is why it was suggested that let there be a sort of assessment done. 2003 Act also introduced a very clear guideline of captive generation, and captive generation was being proposed as one of the significant contributor to make the industry self sustainable, and we have seen phenomenal growth of captive power plant in this country post 2003 Act. So, clear guidelines were being laid down that when an entity will be called as captive power plant under the law. It was also suggested that the transmission segment will have non-discriminatory open access to all, so that there shall be no discrimination on the basis of which entity is engaged in generation and which entity is into distribution of the electricity, into the supply and use of electricity. The reason being that if private generating company is there, then private generating company should not face undue harassment from the transmission licensee in the name of capacity, in the name of lack of infrastructure, and that generating company find it very difficult to get the prospective buyer of the electricity. And that is why it was suggested that let there be a non-discriminatory open access of the transmission system. And in order to make the transmission licensee work in unbiased way, they are not allowed to engage into trading of electricity, so that they should not have any vested interest. Conflict of interest was completely minimized. So, this was an important change in order to ensure that the generating company will find the buyer, and the transmission segment, the transmission licensee will facilitate the buying and selling of electricity without any biasness, which you can very well understand in the absence of the legal backing was not very easy to achieve. Because if the transmission licensee has an interest in the generating unit, then transmission licensee will always give preference to that unit in order to facilitate, in order to look for the buyer. So, this independence to the transmission licensee introduced level playing field for the players in the market, and particularly the private players. And I would say that in a longer term, it is also for the government utilities, I mean it is also for the utilities which are owned by the government, because if the government owned utilities are getting cheaper electricity from the private generating units, they can also buy. 2003 Act advanced the cause of public interest connected with electricity sector, and that is why it suggested that in rural areas there shall be generation and distribution license free. They need not go for license. Anyway, generation was made license free for all, but distribution was also made so that necessary investment can take place and electricity for all can be a reality. With this intention, this suggestion was, this provision was included in the Act. And it was also suggested that as far as engaging into distribution business is concerned in rural areas, panchayats can play a role, there can be a cooperative societies, they can play a role, or there can be a franchisee which can play a significant role. So, in this there is a possibility of small players coming forward and participating in this market. That is what was envisaged. Now, 2003 Act also suggested, also introduced multiple licensing in distribution sector, which obviously has not been utilized to its fullest extent till date, but this is a very progressive provision. It allows the end user to get the electricity from the utilities of one's own choice, and a larger reform in this sector is now being proposed, which I will be discussing in later part of the course while taking up the amendment suggested by the government in the year 2020. So, this is like providing choice to the consumer. Let the consumer have this choice that from whom they want to buy electricity. As on date, this is prevalent in some pockets of the country, but not in every region. And if you can draw an analogy, you can very well visualize that how this can work in the interest of the consumer when you look at the liberalization of telecommunication sector. Now, as an end user, you do have a choice to subscribe to one or the other service provider, and because of that very model, you get a very competitive price. Something similar is also envisaged in the power sector, that as a consumer you shall have a choice from whom you want to buy electricity. And it is being imagined, visualized that this will bring necessary competition, and that competition will cater the interest of the consumer. It was also suggested that there shall be a mandatory metering of all the supplies, because as I said that was one of the loopholes under the law. Now, it was said that let metering be a sort of compulsory. There can be variation in the tariff, but then it is essential to know that what kind of consumption is taking place with which set of consumers. And another important milestone is multi-year tariff, wherein the investor, the one who is investing in the segment, is aware of the fact that what shall be the return over a period of time. And it will also allow the distribution utility to plan accordingly. So, multi-year tariff in a way brings in win-win situation for all. It gives a certainty, a confidence to the generating units that this is what will be the return. It also provides necessary space to the distribution utility to build a strategy, and prominently it diminishes the possibility of unrealistic fluctuation of the tariff, unless and until there is a situation of force majeure, some natural calamity taking place, where that whatever has been agreed as a tariff cannot be adhered to, cannot be fulfilled. So, multi-year tariff is a phenomenal change which has been brought. And then the other one is the cross subsidy surcharge on direct sale to consumers, so that the state need not be overburdened to bear the cost. Trading under this 2003 Act was recognized as one of the distinct activity. We have the power exchanges in India now, where the trading takes place, and with the recognition of trading as a distinct activity, conflict of interest in this sector was also minimized. Now, it has been known that which entity is been given authorization to trade in this electricity market, so that biasness can be removed. Obviously, this also will be dealing in modules to come. It is also suggested that subsidies are to be paid by the states. This is in a way putting an onus on the state that better you behave in a disciplined manner and make these state owned utilities perform on a professional basis, otherwise it will bring in undue financial problem for the states. So, in a way an attempt was being made to bring in a sort of carrot stick method for disciplining the errant behaviors of the players. Earlier it was suggested that the appeal from the decisions of the Electricity Regulatory Commission shall lie before the High Court. Now, we know very well that our traditional judiciary is already overburdened, docket is already full with the pending cases, and infrastructural project cannot bear the cost of prolonged litigation. 2003 Act suggested for introducing a new forum to take up the disputes related to the sector. So, appellate tribunal was established under 2003 law, which has been given the necessary jurisdiction to hear appeal against the decisions of CERC and the SERCs. The idea was to have the combination of both judicial as well as technical expertise to resolve the issue, and it was also suggested that such issues are to be resolved in a speedier manner, so that litigants need not wait for ages to get the relief. The new act also promoted the consumer interest, because at the end of the day this sector is addressing the need of the consumer regardless of the categories of the consumers. So, interest of consumer was also considered to be of paramount interest under this law. Therefore, it is rightly indicated right in the preamble of the act. Very aptly it has been said that one of the objectives of this law is to further the interest of the consumer, and in order to achieve this, utilities, distribution utilities are being suggested to create a body of ombudsman, and then there was a grievance redressal mechanism to be introduced, to be brought in by regulatory commission. So, enough provisions were being made to advance the consumer interest under the law. So, from single buyer model, 2003 Act has institutionalized multi buyer model. Now, the buyer has a choice, seller also has a choice to whom to sell and from whom to buy. Now, there are different players in the market. So, it is not needed that the generating unit is owned by the state and it is to be sold also to the distribution utility which is owned by the state. Now, multi buyer model has generated a necessary hope, the genuine hope in the sector. Electricity boards were dismantled and regulatory commissions were being asked to continue to do the job of tariff setting. They were also being asked to lay down the standards which are to be followed by the players of the market, because as I said, if generation has become delicensed activity, that does not mean that they will not follow any specification. So, they will have to follow certain standards, and that is why it is the responsibility of the regulatory commission to come up with the standards for grid, standards for transmission segments. And then regulatory commission has also been given the responsibility of monitoring the performance, that how the different players are following the rules. If not, intervene and make the necessary course corrections. 2003 Act very aptly catered the balance of the industry and also the citizen of the country. I would say citizen because the very focus on rural electrification is not primarily driven by the fact of consumer. It is attempted that everyone should get the electricity, and that is why a special emphasis was being made on rural electrification. So, industry is being taken care, consumer is being taken care, as well as I would say citizen is being taken care. Citizen here, what I mean to convey is with the idea of detaching it from paying ability. And as I said that the law also introduced the necessary redressal mechanism for consumer. So, this is what in a way 2003 Act attempted to address. There was a clear obligation to develop the industry. It was suggested that let there be more competition in the market, so that will advance the interest of the consumer. And then power for all was also the agenda, the aim, the objective, so that no one shall be deprived, no reason shall be deprived of electricity. As I said in one of my sessions, that right to access electricity can very well be linked with the fundamental rights guaranteed under the Constitution. And then it was also suggested that the necessary promotion should be given to renewables. That also is the mandate of the law. And it was suggested that let there be a transparent subsidy policy, so that one set of consumers should not unnecessarily get burdened at the cost of others. And that is why it was suggested that let there be a rationalization of tariff, so that every category is burdened as per the capacity. 2003 Act certainly brought in necessary facelift, necessary improvement in the sector. Particularly the two segments witnessed substantial improvement, generation and the transmission sector. Good amount of investment has happened in generation segment. There is a lot of improvement on functional aspect, on technical aspect of transmission licensee, but then distribution segment, as I said, is still lagging behind, and now the government has proposed a change, so that that sector, that segment also matches up with other two segments. Now, though the Electricity Act largely deals with thermal or hydro based electricity, but then there is a reference also of renewable energy, that the Regulatory Commission has been given the necessary responsibility to promote generation through renewables, and in recent time it has been seen that this very objective of the law is aggressively followed by the Regulatory Commission. Here let me also inform to you that there is a draft Renewable Energy Act also, perhaps with this idea that renewable segment requires a focused approach, and for that a separate law is needed, but that is still a draft, it has not been brought into force. I will be also dealing with the salient feature of that law in due course of time. So, this 2003 Act brought in captive power plant in a prominent role. It has given the structuring to renewable purchase obligation. It has provided for parallel licensing, and it has also made open access a reality, which will be a subject matter of discussion in the coming sessions. These are the references for module 1, and with this I conclude the session on module 1. Thank you very much.